All right, today, May 2nd, it's just a couple minutes before 11 a.m. I'm Judge Trigg, I'm talking to one counsel appearing in person as well. Counsel may have your appearances.
Brian Minetta, Your Honor. Met Shiro Minetta for the plaintiff, Raymond Trigg.
Thank you.
Bruce Rosen, Pashman Stein, Walter Hayden for the defendant, Charles Kratovil.
Yep. And this is the matter of Raymond Trigg versus Charlie Kratovil and John and Jane Doe's 1-10. It is docket L 576324. Before the court today on an order to show cause. And I reviewed all your papers and submissions and attachments, and quite frankly, I compliment both of you. The papers were extremely well done. Counsel, I want to hear from you first. It's your application. I'm going to have some questions, so if I do interrupt, I apologize, but it's just going to help me focus a bit on my decision making. So.
Sure. I don't want to repeat what I was only involved in the reply brief, but I don't want to repeat the volume that's here. But in a nutshell, the law applies to communication in a government proceeding, or it applies to any matter of public concern involving freedom of speech of the press. And we've said in our papers, and we've given very specific examples, how it applies every time Mr. Kratovil was to appear at a school board meeting that's considering hiring or whatever. That would apply. It would also apply because this is freedom of the press. And in that vein, the Senate case before the Supreme Court talks about almost a presumptive determination that the media, what the media says and does, involves some matter of public concern. So I believe that in at least there's 3 ways to do it under UPEPA, the Uniform Protection Act, and I believe that we meet all 3 criteria for the act. Any questions on that, Judge? I'm happy to deal with that. But then you move on to whether the prima facie case has been established, or whether the motion to dismiss or summary judgment, in this case it's more of a motion to dismiss, should take place. And if so, the case is dismissed with prejudice, fees are awarded. If not, there's an interlocutory appeal, and we go from there. So I just want to start with the complaint, and just looking at the complaint. And I've done a lot of this, and I don't mean to testify, but I teach defamation law, and I also have argued about 5 or 6 of these cases already. This one is especially interesting because the article is 5 years old, or almost 5 years old, and nothing that's said in the article is really disputed. What this seems to be is that the plaintiff believes the article is being repeated too many times. And as a matter of fact, in many of these cases, and I can go through each one of them.
Well, I agree with that to the extent that it's the argument that it's reoccurring, but I think they do take in their papers and argue that what was said in the article was not accurate, because for a couple of different reasons. One, they said that because they mentioned stalking and harassment, and that occurred back in April 2020, and the Missile County Prosecutor's Office investigated that and determined that there was no harassment or stalking. And then the article was published many months later, and the argument is that your client may have known that, and if so, we should be provided with discovery because that could be actual malice, among many other arguments.
Okay, well, that's a fair question. So, first of all, anything that was said in the original article in 2020 is way past the statute of limitations, because what they are essentially arguing is that this is defamation. things were said and they're wrong. Just as Your Honor just pointed out that harassment and stalking should have been used, it's defamation. You can call it intentional infliction, you can call it tortious interference, and there's cases are out there, whether it's Decker or Hustler versus Falwell from the U.S. Supreme Court, or any of these cases, you can't use these ancillary torts to get to defamation, because the First Amendment protections, and not only in New Jersey, it's especially prevalent or important, because you not only have those First Amendment protections, you have common law protections. There's a common law fair common privilege that comes from dairy stores and turf lawnmower and Sisler, and then it goes into Senna, and it says we have anything that's a matter of public concern automatically requires actual malice. And there's a case from 2023, and I don't need to go all over the place. I'm going to come back.
No, that's fine.
In 2023, there's a case called Neuwirth versus State. And I was involved in another case that confirmed Neuwirth versus State, which was Herman versus Mohammed, which was just about a year ago, not even. I think it's like October it was decided by the appellate division. And in both of those cases, the appellate division said, without any equivocation, that there needs to be a factual basis for actual malice in the complaint. It has to be pled. We're not going to discovery to find out what the actual malice is. You have to plead it. That's a very difficult standard, because it's subjective knowledge.
Mm-hmm.
So you have to go into Mr. Kratovil's head at the time that he published it. But there's several layers to this, Judge, because first of all, you're way beyond the statute of limitations. You're beyond the statute of limitations until 1 year before this complaint was filed. So any complaint about anything that was filed before that point is not actionable, just not actionable. So let me just go through the complaint as I started, and I hope that I answer your questions. So nothing said in that June 2020 article is actionable in 2025. There's case after case, and petrolubricant is the most recent case of the New Jersey Supreme Court. Once you publish an article, that's it. You can't sue over it several times. It's the single publication rule is what it's called. So let's go to paragraph 24, August 2020, 3 months later, the board meeting. He speaks, right to express his opinion, and it doesn't really matter because that was more than 5 years ago, or 4.5 years ago, and that's not actionable. February 21st, that's paragraph 28, what he's complaining about involving Rider University is that the article from 2020 caused an issue. Somebody Googled it. Judge goes right back to petrolubricant. This is you can't sue over something that is out there. It's published already, and it's way past the statute of limitations. So there's like several layers of protection for that speech. There's nothing in paragraph 28 that is remotely actionable. Letters to Rutgers in 2021, it doesn't really say exactly when that was. He's a part-time lecturer. It doesn't include any language from those letters. It doesn't say exactly what it was. It doesn't matter. It's way beyond the statute of limitations. But there's other cases, very specifically Overlook Hospital case, Mealy versus Rosenblum. The exact words that are spoken, who uttered them, have to be in the complaint. That doesn't exist. So that's not in the complaint. Okay, paragraph 40, August 21st of 21, East Orange Public Schools. Again, they Googled it, claimed for the article from 2020 caused the issue. Again, it's not actionable for several reasons. Petrolubricant, it's not actionable because the statute of limitations is absolute, and the statute of limitations is no discovery rule. It is the strictest statute of limitations in New Jersey, I believe, and you just can't get around it. And there's case after case that you can't get around it.
Mr. Rosen, the counsel for the plaintiff argues two things with respect to that This is an ongoing and continuing claim that's made, and therefore the statute continues. And also with respect to the underlying argument that you're making, that all this really is a result of a defamation claim that hasn't been pled. The plaintiff argues that the court in Decker limited the complaints where the defendant is being sued based on a tort theory as well as defamation, and there's no cases that just say otherwise.
I believe, I didn't write the original brief, but I'm positive they're in there, and I'm positive I put them back into the reply brief as well. There are numerous cases that say you can't get around the defamation claim like that. And as to the continuing violation theory, it does not exist in defamation. It does not exist. There's no, like, there's a conspiracy, the conspiracy started here, and it keeps going on. It's not like that. The words that were spoken at that particular time were the words that were spoken at that particular time. That's the actual malice that needs to be determined at that particular time. That's the actual malice that needs to be pled at that particular time. That is the rule. It's the reason for that is because we're dealing with a First Amendment basic right. And we're not only dealing with it under the federal Constitution, we're dealing with it under the state Constitution, and we're dealing on this fair comment privilege that the New Jersey Supreme Court has ruled on time and time again, most recently in Senate, I believe in the early 2000s, or I mean 2008, but that is the law. That is the law in New Jersey. There are protections, especially for the media, that exists in a few places in the United States. They exist in New Jersey. But if I can continue, and please interrupt me, Judge. So we talked about that safety director job, December 21st, that's paragraph 42. Again, claiming the article from 2020 caused the issue. Then Google the article. These things are, if I could suggest to the court, as I go through them, I hope that any time that anybody claims an article from 2020 caused an issue because they Googled it, it should like check off like that. It's like we're arguing. That's just striking. Paragraph 44, January 22. Kratovil tweets Lieutenant Trigg's the highest paid, and there's a link in there about the 2020 article, a link to the 2020 article. So what is really happening around that paragraph 45 is that apparently Lieutenant Trigg had paid a reputation company to lower. It's basically called a negative SEO, and he paid them to lower it by adding positive things to the search engine so it would divert people. And he paid, whatever he did, he paid it, and now he's really complaining, I'm going back up there because you've retweeted this article and somehow people are looking at it, and that's what's happening. But by the way, as Ms. Griffin pointed out in the initial brief, New Brunswick Today is not the only publication that published these things. There's the Tap Into New Brunswick published several articles as well. So again, there's just so many layers here of non-actionability.
Can I focus you on paragraph 49?
Sure.
It says, and I take it this was sometime in 2023 or so, at the meeting, defendant advocated against plaintiff's name being included in possible substitute teaching hirings in the local school. Defendant stated he, quote, noticed a former New Brunswick police lieutenant who resigned in disgrace, close quote, was on the substitute teaching list. Now, this is in 2023. The comment is really continues with respect to resigning in disgrace, because the argument from the plaintiff is that he never really resigned, he retired. That comes in 2023. Is that,
but
is
it's
that
October.
survive?
It's October of 2024 that starts the statute of limitations. So looking at the complaint and when it was filed, it's October 10th, 2024. So
right.
It's October 10th, 2023. This is before that. So add there's something called substantial truth that exists in defamation, and it's pretty important. It's really one of the foundations of New York Times versus Sullivan, is that you don't have to be exactly true. You need to be substantially true. And saying you resigned in disgrace is an opinion, because he was reprimanded, he was under investigation, he was the head of an SVU unit and removed as from that SVU unit. These texts, which were disgraceful in themselves, showing, when you look at those texts, if you don't think harassment and stalking, you know, the law requires that you look at the plain meaning. It doesn't look at a dictionary definition. You don't look at the criminal law definition. It tells you to look at the plain meaning. And the plain meaning of what you see in those texts is that this person is stalking. 43 times you're calling somebody in the same day. You're going over to their house. They tried to hide their address from you, and you're out there searching. That's the language that's inside those texts. So all of that, the plain meaning of stalking and harassing is that's what it is. When you read those, you think stalking and harassing. But putting that aside, obviously that paragraph 48 is beyond the statute of limitations. And when he said he resigned in disgrace, he was saying, yeah, he left. He resigned, and I think it's in disgrace. He definitely resigned, and he didn't say that he was fired in disgrace. He said he resigned in disgrace. How is that not a matter of opinion? It's not verifiable. How do you determine whether something is opinion or not? You look to the verifiability. How do you determine whether something is defamatory or not? You look to content, context, and verifiability. So verifiability is really the primary determinant in opinion. And if you're setting forth a set of false facts, and then you're relying on an opinion, it's a little bit of a different story. But here, he has not disputed the basic truths that are in that article from 2020. He just keeps saying, you keep repeating it, you're killing me here. That's really what he's saying. And you know, there's no tort that gets to that. You're allowed to do this, and half the time, at least half the time, he didn't even do it. It's the school district, so the college that's looking, and they're Googling this, and they're seeing that this happened. It happened, Judge. It really happened. You know, maybe he doesn't deserve it. That's not the issue here. The issue is that the article was published, articles were published in other publications, and they exist. This is not Europe. You can't, there's no right to be forgotten, and I'm not sure you get a right to be forgotten after 5 years. And I'm not sure you get a right to be forgotten if you were a public official when this happened. But there's no right to be forgotten here. 52, speaking engagement canceled. Again, he claims the article from 2020 caused the issue. That had nothing to do with Mr. Kratovil. 55, he appears again and urges a reading of the 2020 article. It's his right to say it. If he said something else in August of 23, that specifically those specific words, perhaps he could have used a defamation claim, but it's August 23, it's not October 23, and so it's beyond the statute of limitations, and he didn't put the specific words in there anyway. I'm just going through the checklist in my mind as to why this is not actionable. Okay, 61, October 23, doesn't say exactly what it is, but even if you assume that it's under the statute of limitations, that it's within the statute of limitations, claims the article from 2020 caused the Plainfield Board of Ed to not hire him. Again, we're dealing with the single publication rule. So then you go to paragraph 66, October 17th, Kratovil attended the New Brunswick Board of Education, made unspecified public statements and repeated items from the article. Look at it specifically, since it's within the statute of limitations. He made comments objecting to plaintiff's employee appointment and once again announced the news article he published in 2020. He continued to state the charges and text messages contained in the article. There's no allegation of defamation there. It's just an allegation. You're repeating this again. You're killing me. I'm trying not to use the vernacular, but that's really what the sense that you get from this is, stop already. Stop talking about me. I need to get a job. But Mr. Kratovil, for his reasons, and maybe the reasons of a lot of other people, believe that his behavior was not appropriate for a public safety officer, and he shouldn't be employed in these positions, teaching children or acting as a public safety officer. It's his right. He doesn't have to be right in terms of correct. You know, it's his right under the First Amendment, under the common law, under the New Jersey Constitution, to say these things. It's his right to say these things. So we're talking about paragraph 68, and then paragraph 74. This is like, I don't know where this comes from, but he makes this OPA request, and I believe it's this court that denied it. How does that become a crime or a tort to ask for an OPA request, especially for a newspaper reporter? Basically they're saying, by even doing that, you're sometimes tortious interfering, or you're giving me emotional distress. I mean, let's just take the First Amendment and turn it on its head, because that is not actionable in any sense. Paragraph 76, January 23rd, 24. He goes to a town hall meeting, he attempts to film and ask questions. That's what reporters do. There's no allegation that he touched him, he pushed him, that he made him feel unsafe in any way. He attempted to film and ask questions. It's simply not actionable. If that was the case, the entire media would be, you can't ask a question that someone might find objectionable for you to actually even ask the question, because that's what happened. Paragraph 82, the Plainfield job, it didn't get it, claims the article from 2020 caused the issue. Every one of those where he claims the article from 2020 caused the issue, right out the window. They're just, none of them are bona fide, they're all not actionable. And let me point out that the third count here is false light. And false light is, according to at least the appellate division, if not the Supreme Court, it is a claim of defamation, and it's subject to the same statute of limitations. You can look at Swan versus Boardwalk Regency, 407 New Jersey Super 108. The appellate division said it is essentially a claim of defamation, and you need actual malice. So, where does that leave us? We just went over the entire complaint, and the entire complaint is not actionable. But even if the court were to say it were actionable, there's no pleading of actual malice here. There's no pleading of what Mr. Kratovil knew at the time each thing was published, assuming, except for the 2020, you can't even entertain those, Judge, that they look back at these various publications and somehow he was responsible for that. That is petrolubricant and many other cases, single publication rule. Once it's out there, you can't sue over it, period. So basically, this plaintiff, and I understand he wants to find a job, but I also understand that Mr. Kratovil has a right to say these aren't the right kind of jobs for you in the public sphere after what you did. And maybe Mr. Kratovil's wrong, but it doesn't matter whether he's wrong, because what matters is that he has a right to say these things, and so do other people. And as a matter of fact, they may be complaining about what happened to New Brunswick did, because they don't say exactly who Googled what. They don't say the administrator said they Googled and saw this. They said they Googled and they saw the issue. Now, I was involved in a case years ago as an amicus in, it's called GD versus Kenny. And in that particular case, it was about expungement. And in GD versus Kenny, a political candidate published a flyer, and it said this person was accused of selling drugs within a school zone. And he was convicted of it and got off, got PTI. And in that particular case, GD versus Kenny, he got PTI, so they're arguing, well, it's not really a conviction. But in any case, we expunged it. And the New Jersey Supreme Court said, you can't edit history. That's not the way it works. You can't edit history. It happened. It happened. You can't forget about it. Those who know about it, the expungement takes it off the table as far as inquiring with state authorities, but it doesn't remove it totally, Judge. So that is, since sort of this, the plaintiff here wants to remove this. He wants to take this away. I want to get on with my life. I understand that. But that's not how the world works. And it's certainly not how the law works in New Jersey.
Mr. Rosen, one of the alternative arguments counsel makes is that if the court finds your arguments to have merit, is that they should still be permitted some discovery or at least an opportunity to amend the complaint with respect to some of their arguments. One, to prove malice, or those claims that may survive after the statute and the like. What's your take on that?
Well, Judge, I think the statute is very clear that if you find that this is a matter of public concern and there's enough here for a motion to dismiss, which is very, very common in defamation cases, and we included a bunch of those cases in the papers. This case is dismissed with prejudice. There's no coming back in it. Secondly, discovery is the reason why these cases when this law was enacted. The whole purpose of the law was to expedite determinations where someone is trying to curtail speech. And there's no clearer example of curtailing speech than what Lieutenant Trigg is trying to do in this particular case. He's trying to stop the speech from 2020 from coming out again. That's what he's trying to do. So it goes directly to the statute, and the statute is actually a presumptive stay of discovery while the case is going on, but it also is meant to curtail the expense of discovery. If you look at the history of anti-SLAPP laws, I mean, the whole purpose is these are very expensive. It's meant to intimidate. Most people who file these things don't even care whether they win or not. They just want to intimidate. They want to push down that speech. They want to end that speech, and they'll do it. It's like a developer who people are protesting against his development, and people are then sued for tortious interference or something like that. And the whole purpose of the statute is to give them a way to expedite a resolution and get legal fees and not have to deal with this again. And that's what's happening here, Judge. This should be dealt with expeditiously. There's absolutely no reason for discovery whatsoever. He didn't plead actual malice. If you don't plead it, you don't get another shot at coming up with it. In the Herman case, they gave them another shot, and they weren't able to do it, and they're not going to be able to do it here. And it doesn't much matter, because if the judge finds that they didn't do it, that's the end of the game under SLAPP law, under the anti-SLAPP law. There's no getting around that. Any other questions?
Mr. Rosen, thank you. Counsel, before you get started, Mr. O'Connell, we give it a new date, right?
Yes.
Last year was May 9th.
Yes, so I have to talk to you about that.
I'm on
You could just,
vacation.
you're on, you told me you had
I-
only wanted me
And I
to.
was upstairs and the light bulb went off that I won't be
No,
here next
all
time.
right, we'll
We'll
reschedule.
talk about it over email. I'll email you.
But thank you.
Yeah.
Sorry to interrupt you.
No
Thank you.
worries. Okay, I'm sorry, counsel.
Good morning.
Good morning.
I want to make one thing clear from the outset, Your Honor. This case is not a strategic lawsuit against public participation. We certainly care if we win. It was not filed for any other reason but for the claims in the complaint. This is not a case against the media. This is not a defamation claim, most importantly. This is a tort claim seeking economic damages for wrongful, malicious, and unconscionable conduct of the defendant. The conduct has been consistent and ongoing for the last 4 years, and it has caused the plaintiff, Raymond Trigg, to lose multiple jobs that he had and multiple job opportunities. Here, the defendant is using the privileges afforded to the press as a sword to ruin plaintiff. Defendant's conduct goes far beyond investigative journalism and crosses the line into tortious territory, and the court can't allow this to happen. And therefore, the complaint in this matter can't be dismissed, and the matter must be permitted to proceed. As you read in the papers, which you obviously read very carefully, plaintiff was a police officer for the city of New Brunswick for 27 years. He rose to the rank of lieutenant. At some point, he had a relationship with a woman. They broke up. The woman alleged that he harassed and stalked her. Those claims were fully investigated, as you noted, by the Middlesex County Prosecutor's Office and the New Brunswick Police Department's Internal Affairs Unit. As we put in our papers, Exhibit B to Mr. Trigg's certification, on April 27th of 2020, the prosecutor's office said there was absolutely no evidence to support that claim. Internal Affairs investigation resulted in a written reprimand, and plaintiff retired. He retired after 27 years of service, effective August 1st or July 31st, if there was a question of what date that you retired there. 2 months later, the defendant writes this article. And when you look at the language of the article, which we have in our Exhibit C, the title is Commander of the Domestic Violence Unit used NBPD phone to stalk woman. It's unequivocal language. This language makes it seem like Mr. Trigg stalked this woman and was either accused of or convicted of stalking her. That never happened. The first sentence of the article states, the police lieutenant in charge of handling domestic violence and school matters used a city-owned cell phone to stalk and harass a young woman, sending her lewd pictures taken at police headquarters. The stalking and harassment there are completely unsupported and unsubstantiated.
Well, under the legal definition, because he was never charged, but, and you know, there's, I understand that the article doesn't say allegedly, you know, stalked or harassed, or believed or stalked or harassed, or wherever you want to put in there. It says that it was stalking harassment, but under a more common definition, why would that not be permitted? Because he did, it's recognized that he sent, I don't know, almost 40 text messages and showed up at the victim's residence, and then she ultimately filed charges against him, or had asked for a restraining order anyway, temporary restraining order, for stalking and harassment.
Correct, but he was never criminally charged, and he was never criminally convicted. And the way it is presented in that article is very clear that he has committed a crime. Just like in the restatement that defendant cites in his brief. I believe the example is, I think John is an alcoholic. It's very clear. And when you go further in the article, it talks about how the state police have reported that harassment and assault are the most common domestic violence offenses. It makes it appear very clearly that Mr. Trigg was convicted of that. But that article, Your Honor, if all it was the article, as defendant points out, there were multiple articles. There are multiple articles written. We haven't sued any of them. And we haven't sued any of them because this case is not a defamation case. It's not about just what the article says. It's about the conduct of the defendant in this case. And the defendant in this case has made it his mission to ruin plaintiff based on this contention that he committed these crimes. He went to these Board of Education meetings, and he told them. And when he goes to the Board of Education meetings, which is, part of it is transcribed in Counsel Griffin's certification, He doesn't say anything about how these claims are unsubstantiated, or that they never came to fruition, or there was no criminal charges filed. He just says he stalked and harassed them. And again, we haven't sued any of the other papers because that's not what this case is about. This case is about the economic losses suffered by the plaintiff because of the defendant's conduct. That the article was the June 22nd, 2020, and then there were multiple tweets, as you know, which we've attached to our certification. And those tweets say that plaintiff resigned, the one in July of 2020, and then one 2 years later, August 21st of 2022, or January 21st of 2022, I believe, where he says he resigned in disgrace. Now, for a police officer, resigning is much different than retiring. Retiring is you've completed your career, you've gone through it, and he served 27 years, and he retired. He didn't resign in disgrace. He received his full pension from the PFRS. It's just not true. Those tweets aren't true. And going further, now in May of 2023, he appeared at the North Brunswick Board of Education meeting, and he said, you know, plaintiff, Trigg, stalked and harassed this woman and shouldn't be a substitute teacher. It's not true. He didn't stalk and harass her. He was never convicted of those crimes. Then again, in October of 2023, plaintiff goes to the New Brunswick Board of Education meeting and gets Trigg fired from his job, which he'd already started. But perhaps the most egregious thing here is that plaintiff was a part-time lecturer at Rutgers for 6 years. The defendant writes Rutgers letters, and he gets fired from that job. Now, again, the complaint in this matter is not a defamation complaint. We have made the complaint of tortious interference with prospective economic advantage, intentional infliction of emotional distress, and false claim. And we don't believe Uniform Public Expression Protection Act actually applies here. First, as you know, UPEPA protects communications in a legislative, executive, judicial, administrative, or other governmental proceeding, communication on an issue under consideration or review in a legislative or executive, judicial, administrative, or other governmental proceeding, or the exercise of the right of freedom of speech of the press, the right to assemble on a matter of public concern. Plaintiff's complaint only cites the 3 instances where the defendant had gone to the Board of Education meetings to ultimately prevent or have the plaintiff terminated. So all of the other allegations in the complaint are outside of those meetings. And as far as the issue with public concern, plaintiff was a police officer. He was a lieutenant. But this comes from a private relationship. A private relationship is not a matter of public concern.
I don't know, I think I may disagree with you on that, because at the time, yes, he was on duty at the time that he was making these, and he was using a phone that belonged to the New Brunswick Police Department, so.
Yes, but as one of the articles that was appended to Council Griffin's certification does say, he was allowed to use his phone as a personal phone.
Yes.
But only 2 things, Your Honor, happened. The June 22nd, 2020 article and the first tweet indicating that plaintiff resigned when in fact he did not. Those are the only 2 things that actually occurred during the period he was employed. After he retired is when everything really started to ramp up.
But
That's
is it
when,
really just a repetition of what happened in 2020? What happens in 2022, 23, 24, when he's going to these board meetings and he's contacting the schools and the like and potential employers? It's all goes back to the 2020 article.
and the false claims that he harassed and stalked somebody around. But each instance is a new instance here with regard to the complaint. And let me get back to answering your question.
Can
At
you
that point, he
hold
had
that-
already retired.
Can you hold that thought for a minute? Because Mr. Rosen, this kept coming up when I was reading these cases, is this. Under the argument that's being advanced, with respect to everything is grounded in defamation, therefore you have a one-year period statute, what happens in the case where somebody is silent for 4 or 5 years and then starts coming after somebody on a comment that was made, and they are interfering with their livelihood? You're saying that claim is never actionable because it wasn't pled within a year?
That's correct. You
Right?
can't- you
Because
can't-
that's basically what the argument is.
You cannot, I'm sorry, Judge.
No, go ahead.
You cannot plead, just now I heard, the way it was presented in the article, the tweets aren't true, this is all about the truth of what happened there. We just keep hearing about that why the articles are false, and yet he says it's not about defamation. It's about basically how you used the article. It's defamation or it's nothing.
But now he's able to come back in and say, all the investigations are over with, I've been cleared, and you're still doing this, and it's wrong because now it's interfering with my livelihood. Why isn't that action?
Judge, first of all, the clear is one thing, but he had an FRO against him. I think that's in the record as well.
But that,
Okay, but he
ultimately, right.
But he had it. It was there. The woman accused him of stalking. What the police said was, we're not going, or the prosecutor's office said, we're not going after you for this. But he was reprimanded for it. But it doesn't much matter, because if you look at these 43 text messages and the calls, the 43 calls, the text messages, you could look at them, Judge, and in plain meaning, show them to 100 people, and a judge has to do what a reasonable person would say, not what Black's Law Dictionary says, or not what the prosecutor's office says. It's a plain meaning. You're looking at the plain meaning by an ordinary person, and the person that's going to see that, and you combine it with the FRO, and you have stalking and harassing. That's what it is, because it's, oh my God, you're stalking this person. That doesn't mean that's a criminal charge. It's a common term. You're stalking me. You're going after me. And harassment? If 43 calls isn't harassment, I don't know what is. Now, whether it's harassment under the law is a whole different issue, because it involves mens rea and all and whatnot. And I've actually been involved in those cases. But that's not the point here, Judge.
Thank you. You answered my question. I appreciate that. I'm sorry to interrupt you, but I just, one of those things that come back to.
No, of course, sure.
Go ahead.
Absolutely no problem. But with regard to public concern, he retired August 1st, 2020. He was no longer a police officer. And yet, every time he goes to get a job, the defendant appears. And he's prevented from doing it. He's prevented from getting that job. And it's, how long? How long does this continue to be a matter of public concern? Forever? Is he going to be protected by UPEPA forever? Anytime he says something till the day that Mr. Trigg passes away? It's absurd at this point for this still to keep coming up, and it's come up as late as last year. And you know, we're not saying that the OPA request was part of the facts. We're not claiming that is cause of action on the OPA request. But you know, at the time,
If the court were to accept Mr. Rosen's argument that this is all, rooted in defamation, would there be any claims that would survive?
absolutely, Your Honor, absolutely. most specifically the tortious interference with prospective economic advantage claim. And
But wouldn't those claims also, they're all derived from the 2020 article?
no, those claims, Your Honor, are derived from intent. There is a case, it's from 1943, from the Supreme Court of Monmouth County, back before the court reconstruction. It's Strollo versus Central Jersey Power and Light Company, 20 NJ Miscellaneous, 217, 1942. And in that case,
Could I interrupt you and ask you where this is?
it's not in our papers.
Because I would have to pull out probably one of the books. Could you please give it to me one more time?
Yes, Strollo, Strollo
Yep.
versus Jersey Central Power and Light Company.
Uh-huh. It's 27, I'm sorry, what was the site?
20 NJ MISC, 217, 1942.
Okay.
And in that case, an employee of Jersey Central Power and Light somehow rubbed someone the wrong way, and a group of people started spreading these rumors that he had stolen juice and was tampering with electrical boxes. And ultimately, because of that, the plaintiff was terminated from his employment. The defendants moved to dismiss the complaint on statute of limitations grounds because the complaint was filed more than 1 year after the statements were made. The court stated, the act of an individual who maliciously and without justifiable cause induces an employer to end the employment of an employee is an actionable tort, regardless of whether the inducement be by false slander or successful persuasion. The court went on to state that the causing of the loss of the person's employment wrongfully and maliciously is actionable. It cannot be contended in the instant case that slander is the gist of the action. The gravamen of the complaint under consideration is alleged wrongful intent on the part of the defendants to maliciously cause the plaintiff to lose his employment. Slander was the means allegedly used by the defendant to accomplish their wrongful design, but their malicious intent, rather than their alleged slander, is nevertheless the gist of the cause of action. And that case moves forward up to Patel versus Soriano, 369 NJ Super 192. The gravamen of a complaint for malicious intent to cause harm to one's business or employment is not the means used, but the wrongfulness of the defendant's intent. It is not necessary to set out the words of the false representation. For such a cause of action, the more restricted statute of limitations for slander does not apply.
Well, I mean, that's tort law. That's a different tort, and that's indeed plead that tort. Judge, that's product disparagement, trade libel.
That in Patel versus Soriano, yes, but obviously in Strollo, as I said, that's employment. And that's exactly what happened here, Your Honor. Plaintiff wrote letters to Rutgers University. He went to the Board of Education meeting in New Brunswick. And he stated that plaintiff was a harasser and a stalker. And he ultimately lost the job that he had already started. There's literally no reason anymore for the defendant to keep following and hounding the plaintiff. At this point, he's not a police officer. He retired. He's just trying to get a job. So certainly that claim would remain, and I think all of the claims remain because we never pled defamation, Your Honor. How can these defamation defenses apply when we don't plead defamation? It simply doesn't make sense here because the defendant wrote this article. And again, if it's just the article, it's just the article. But he writes the article and then continues to harass and follow, stalk the plaintiff until he loses all of his jobs. He loses his livelihood. Those are torts, making tort claims. And we certainly have pled, and I don't think there's any argument that we have made a prima facie case for the tort claims that we've alleged.
So even if the court were to accept your argument, let's stay with the stalking for a moment, that he went to these school boards and these meetings and whatnot and said, I wrote an article in 2020 and this gentleman did stalking and harassment. Okay, so now they look it up and they look up the article. They can certainly ask your client, well, what's the background to this? But they just decided not to engage his employment or to terminate him, allegedly, at least from the one affidavit, because of the article. But you would have to say that the article is false and misleading. Is it false and misleading because there's a comment made that he was stalking when he communicated 40-something messages to somebody? Is it?
When, at the time that article was written, Your Honor, the prosecutor's office had already made the determination that there was no evidence to support the stalking and harassment charge. And that was communicated to the plaintiff, and it was easily verifiable by the defendant. Easily verifiable by the defendant, because if he had been convicted or charged, it'd be a public record. So in the absence of that, it's easily verifiable. It just wasn't true. And the other tweets that he resigned in disgrace. He didn't resign, it's not true. He retired, and again, that's a big difference. Resigning makes it sound like someone has done something wrong. Retiring means you've completed your service, especially for police officers, and the PFR has 25 years. It's different. It's supposed to be a celebration. You got through it. You made it through your career. You didn't resign in disgrace. You retired. And, you know, for the defendant then to turn around and continue to write letters to Rutgers to get him fired, and to show up at these Board of Education meetings constantly, he is causing great economic harm to the plaintiff. And that is why we filed tort claims. Again, defamation is a completely different cause of action. We weren't looking to avoid the statute of limitations. We weren't looking to avoid any defenses. But we've pled appropriately the tort claims that we've advanced. And there's not been any argument to the contrary. The question here is whether those defamation defenses apply, whether the statute of limitations applies. And with regard to certainly the tortious interference prospective economic advantage claim, it doesn't, because it goes to the intent. Why is the defendant doing this? And he's doing it to ensure that plaintiff is never works again. You know, and so we've made under the statute, I understand you disagree with me about the public concern issue, but under the statute, we've made prima facie claims as we set forth in our brief, and I can talk about them too if you'd like, but there's not been an argument that we haven't made prima facie claims for tortious interference.
Let me ask you this. If Mr. Kratovil went to the school board and said, this person you're about to hire text a young lady 43 times in one night and went to her residence and stayed there, is that the person you want to hire? Is that actionable under your theories? False claim, interference?
I don't think it was 43 texts, I believe, Your Honor, it was 43 phone calls.
Wait, there's phone calls and there's also text, but
Yeah,
you're right, maybe it wasn't 43.
Yeah,
You're
just
right.
the number of 43, I
Well,
apologize.
it's my mistake earlier.
No, you're right. He was repeatedly calling and left messages, yeah. Anyway, would your claim still be actionable?
I believe so, yes, because it's the intent. Why is he doing that? Why is he doing that? That's what the tort law is concerned with. We're not concerned with the defamation piece. We're concerned with what is his intent, what is the malicious intent here. And the malicious intent is proven through all the repeated and constant coming, and every time he goes for a job. And writing letters to Rutgers, that's not the job of the press. That's not an activity of the press, that's not investigative reporting, that's getting somebody fired, just like in Strollo. And also, Your Honor, we have set forth fully in our briefs also that even if you do determine that the one-year statute of limitations applies, which we don't believe that it does, that there are several instances within that one-year statute of limitations. For example, attending the New Brunswick Board of Education meeting in which defendant again stated that plaintiff used the city-owned cell phone to stalk and harass a young woman and send lewd pictures using that phone. And as a result of that, he lost his teaching job. He's also denied the opportunity to work in the Plainfield Public Schools after he signed the contract because of that article. And again, we didn't have to allege actual malice because we didn't plead a defamation claim. There are 3 claims: tortious interference, intentional infliction of emotional distress, and false light.
False light requires actual malice.
And I think certainly we've shown that in our complaint. Defendant rather, clearly had a disregard for the truth. He knew, and the article itself is evidence that he knew, because much later in the article, after the first sentence in the title, he stated that he had a conversation with the New Brunswick Police Department's internal affairs captain, and the prosecutor's office said that there was no evidence to support criminal conduct. But he never really tied that back to the stalking and harassing claims. It's just thrown out there. So he knew that that wasn't true, that he didn't stalk and harass anyone. It's not hyperbole. It's not an opinion that somebody stalks and harasses somebody, especially in that context. When you're writing an article about a police department, about the conduct of a lieutenant, and when you say that the state police is advised that harassment and assault are the 2 most common domestic violence offenses, it very much makes clear, at least to the reader, that Raymond Trigg was either accused or convicted of stalking and harassment, especially the title of the article, NBPD Commander Stalks Woman. And it's just not true, Your Honor. Again, also the tweets, not true. He didn't resign. But resigning from a police department job certainly can be a reason that other public employers won't hire you. And we show that, and it's very easily determinable if somebody retires. All you have to do is Google it. PFRS has a list of everybody that retires. They don't have a list of everybody that resigns. So those statements, Your Honor, those statements are false. They're not true. Never convicted or accused of a crime. And plaintiff has made a prima facie showing for the tortious interference with prospective economic advantage claim, as well as the intentional infliction of emotional distress claim, and the false light claim as well. There's certainly, when reading the pleadings liberally, as you must at this stage, enough there in the complaint to show malice. Again, in paragraph 20 is when we discussed the first tweet on July 22nd that he resigned. Paragraph 21 says plaintiff retired from the department. Again, it's not difficult to figure out if somebody retired or resigned. It's very public. Similarly, the second tweet in August, also false. He never resigned. He retired. So obviously, for the reasons set forth in our papers and the discussions I've had today, we submit to you that first, UPEPA does not apply because we don't believe this is a matter of public concern. I will say that part of our allegations do concern the meetings.
Let me ask you about this, the resignation, right? Because the first tweet happened back in 2020.
Yes,
He
July.
says two major victories to announce today. One was Lieutenant Raymond Trigg has submitted his resignation effective 8/1, which was actually September 30th, and you're saying that that's false. And then later on is when he says that he resigned in disgrace. Let's start with the first tweet, that he submitted his resignation instead of retiring. No problem there, right?
Your Honor, I think that's false. In the police context, if somebody resigns, it's a very clear indication that they have done something.
Okay, so you have a problem with that tweet as well.
Yes.
And then the second tweet, which comes sometime later, is when he says that he resigned in disgrace.
That's January of 2022. Yes, 21st, I believe.
22 or 23, is it 22? You might be right. It was sometime after. So with respect to that, doesn't he have the opinion to say that at that point? Isn't he afforded that luxury, if you will, to say that he resigned in disgrace?
If it was fairly reported, he could say he retired, and then
Okay.
whatever
Because
else.
he didn't retire, because he didn't resign.
Right, it's not true, and I think that's a major distinction here, because in the event that you resign, the public will see that certainly as you've done something wrong and you're trying to get out of Dodge effectively. Because police officers don't resign. They don't resign for political reasons. They don't, very rare. Very rare. But police officers retire, and they retire after storied careers. And the plaintiff here, Mr. Trigg, had no discipline, really. A very, very clean record, except he was reprimanded, which is almost amazing. I know you've heard multiple police cases. Police officers get in trouble a lot. But he didn't. And every time now that he goes for a job, he is hindered. The defendant either shows up, writes letters, and he had that job at record for 6 years, John. 6 years. That's clearly tortious interference. Because what he didn't harass, he didn't sue, he was never criminally convicted of that. But everything makes it look like he did. So for those reasons and the reasons that unless you'd like me to go through the prima facie case of tortious interference and all which
Well,
is,
Mr. Bennett, thank you very much. I appreciate your arguments. Mr. Rosen, what if, let's start with the last couple of comments, the issue of retirement. You know, in some of the articles that were submitted by C.J. Griffin, they do use the words alleged stalking or accused of, but Mr. Kratovil never did that, and he certainly knew back in 2022 and 23 that he retired and resigned, but continues to say he resigned in disgrace. At any moment?
All right, well, putting aside statute of limitations for a minute and the fact that every other word out of counsel's mouth was it's not true, which goes to what the original article and the tweets that are way beyond statute of limitations and shows that this is a defamation case. But putting aside that, there's a case called Durando versus the Nutley Sun, which I was counsel on before the New Jersey Supreme Court. And in Durando, the court said, as in many other cases, you have to look at the complete context. So if they're explaining in the article, at the bottom of the article, it doesn't matter where in the article, because the law assumes that you're reading the entire article, not just the first paragraph, or not just the headline. You're looking at the bottom of the article, it says that he was criminally cleared, but it's still stalking and harassing because it includes evidence of the stalking and harassing, the phone calls, and the text with the lewd photographs. I mean, and the reprimand. So you put those in there, that's stalking and harassing by any plain meaning. So that's one thing. Second thing I need to, I'm sorry, Judge.
No, you're.
Go back to the statute. The statute is all or part. Even if Your Honor were to say, you know, false light requires as an element, you must have actual malice, and Neuwirth and Herman tell you that you need to plead it, and you just admitted you didn't plead it because you didn't think you needed to plead it. So, just on the outset, as a matter of public concern, false light is being defamation, everything's beyond the statute of limitations anyway, and he didn't plead actual malice. That's a slap, right there, that's a partial slap. You go back to everything else, and you have to widow out every time that you see this article and somebody looked at this article. Petrolubricant takes that right out of the complaint. And the cases that merge, that tell you that you can't overcome defamation by pleading other torts, including Swan, which I referred to before, but Decker and Hustler, you know, where they tried to go by intentional infliction when the defamation count was knocked out. I made a big movie about it, the Hustler case with Woody Harrelson, and in the end, the Supreme Court said, no, you can't do that. You can't go around the certain protections that are involved with defamation. And so, once you widow out all of those times that they looked at it, it's a much thinner complaint. And you're left with what's left after, if you assume that or the court finds that there's some defamation because counsel, and please read the transcript of what we just went through, counsel, almost every other word, it's not true, this is not true, this is not true. That's defamation. You know, and malice, in the sense that he's using it, there's a difference between common law malice, which is, you know, I don't like you and I'm going to get you, and actual malice, which is, I knew I was lying when I said something. And that's not what it's talking about. He's saying this is malicious, and there's a malicious intent in the sense of common law malice. That case from 1942 is interesting, but it came well before New York Times versus Sullivan, and 40,000 cases since then, including several by the New Jersey Supreme Court, which reaffirmed it, recodified it, and expanded on it, including Senna. And in fact, giving it to every matter of public concern. Every time you went before a school board meeting and talked about the qualifications of a person that was going to be employed by a school board, that's a matter of public concern. The other times, he was just simply, they were reading that he wrote this in 2020, or they were reading that Tappington, New Brunswick wrote this in 2020. And so we don't even know that. and you get to the end, saying, well, even if the statute of limitations applied, and so let's look at what happens after the statute of limitations applied in that New Brunswick School Board meeting that he's talking about. October 17th, 2023, defendant attended the New Brunswick Board of Education meeting. Defendant made comments at the meeting objecting to plaintiff's employment. Okay. And once again, announced the news article he published in 2020. Continued to state the charges and text messages contained within the article. He's repeating the article, but they're not saying what he said. The law is very, very strict. Mealy versus Rosenblum, the Overlook Hospital case, you have to say exactly what it is that's defamatory. It doesn't say it.
But he does say in the previous paragraphs
What's in the previous paragraph?
what was being said, that stalking and harassment, right? So I understand your argument, but he does mention it, it's in the previous
But it
paragraphs.
does,
of the
okay.
complaint.
So to the extent that the court would be extrapolating, but okay. But he's repeating something that was said in 2020.
Right.
And
Correct.
so, first of all, he's repeating what was said in 2020. Plenty of people know what was said in 2020. You don't know exactly what he said at this meeting, which you need to know. And all of that was well beyond the statute of limitations. And it's true, or substantially true, because it's not verifiable whether it's harassment and stalking. Because you look at that yourself and you say, my God, that's harassment and stalking. And it explains in the article that he was cleared of it. So then you have to think, well, how else is he getting harassment and stalking? Well, there's the text messages, there's the 43 phone calls, there's the reprimand, there's, I don't know if it referred to the FRO, but that did exist at the time. I mean, it's a plain meaning of those terms. I don't know how the court can come to another conclusion, but I'm not the judge. So I think pretty much that again, just one last thing is the retirement after retirement and resignation after a reprimand, in the context that it was put in there, even in the tweet that had the link to the article, it's the gist or the sting of it is the same. Retire, whatever. You got into trouble. You got reprimanded. You got caught with all these texts on a city phone. You know, you retired or you resigned in disgrace. It's either opinion or it's substantial truth. Thank you, Judge. Appreciate it.
Any final words?
Yeah, just, I'm saying that this, I have repeated myself, but I have those the two criminal words, harassment and stalking, were not true. Those go to our prima facie case for tortious interference, prospective economic advantage, potential infliction of emotional distress, to be sure. Second element, defendant of tortious interference, the defendant interfered with his advantage intentionally without justification. Part of it, that justification was not true. That it is not true that he resigned, he retired. It is not true that he stalked or harassed anyone in the criminal context. The prosecutor's office was clear. He never was accused formally, never charged, not accused but charged, and he was never convicted. In addition, even at the time, and first of all, the statute of limitations for tortious interference is 6 years, because it's an economic injury. And that's exactly what this case is about. The economic injury suffered by the plaintiff for the defendant writing those letters to Rutgers, for ensuring every place he goes to be a substitute teacher. First, he retired to be the security director of the New Brunswick City Public Schools. It's a big job. Defendant showed up at the meeting and he didn't get that job. Now, even as a substitute teacher, a part-time lecturer at Rutgers, which he had held for 6 years, those are the problems And the speech was the way to get there, but it's the intent. The intent. Doggedly going after somebody for 4 years, 5 years now. Intent has got to be presumed there. Why else? Why else would you go after somebody constantly for this whole period of time? You're just trying to ruin that person's life. Again, we are not trying to stifle the media. We didn't sue anybody else, and as you pointed out, the other articles did say it was alleged or accused. But the truth goes to the prima facie case that we fully set out in our briefs with tort claims that we have that we brought here, and also, if this is somehow going to be turned into a case where we need to prove actual malice, which we're looking at intent, then we certainly should be able to amend the complaint under the rules, because that's not what we pled. We pled those 3 torts. It's going to turn into something else. We should be able to amend the plea. But that's all I have. Thank you.
Just one more thing, is that false light requires actual malice. It wasn't pled on its own, it's a matter of public concern. That alone is a slap, and I stand on the rest of the argument for the rest of the complaint. Thank you.
Very good, thank you both, I appreciate your arguments. Have a good day, I'll get you an opinion next week.
Thank you.